We're at the point where we're ready for a major casualty. The room got warm, we ran out of caffeine, and I'm just about to bore you to tears. I'm going to take you back from all the interesting stuff you've been hearing that you don't usually have to deal with to some of those mundane things that you and I have to talk about on the phone almost every day. And that is some of the proposed changes to the condo statute and to the HOA statute. Can I ask about how many, or if you'd raise your hands, how many are primarily involved with condo associations and HOAs? Okay, that's not. I'm mostly going to deal with condos. We'll kind of go that direction, but I'll hit the HOAs as well. First of all, the legislature did pass another bill this year by both houses. It was not a bad one. It primarily is intended to fix some things they didn't get quite right last year. Everybody probably remembers SB 1196 that we heard so much about last year, made some changes. Well, HB 1195 is the primary bill this year. It has been presented to the governor. I guess it's on his desk. That was on the 13th, just earlier this week. He's got a couple of weeks to look at it to decide if he's going to veto it or pass it. I don't see any reason why he wouldn't pass it, but stay tuned because none of us knows, and you may be listening to this and get nothing out of it because maybe nothing's going to change. Let me hit some highlights and some of the things that are going to be discussed. First one is official records. Now, in both the HOA and the condo situation, there's a list of official records that we have to maintain for the association, and both statutes have a paragraph that says all of these official records must be made available to members or unit owners. They use different words, but they mean the same thing. Must be made available. And then there's a little exception in there. It says, notwithstanding all that, these things cannot be made available. And among the things that cannot be are communications from your attorney, information regarding personnel, and information regarding your members. And so let me just read this part to you. This is from the condo statute, but the HOA statute is very similar. It says, notwithstanding the provisions of this paragraph, which requires all official records to be open for inspection, the following are not accessible to unit owners: Social Security numbers, driver's license, credit cards, email addresses, telephone numbers, emergency contact information, addresses other than as provided to fulfill association notices, and other personal identifying information of any person. And then it goes on to say, excluding the person's name, unit designation, mailing address, and property address. The reason I wanted to read that to you is because it doesn't make a whole lot of good sense, and I know that it generates a lot of work for attorneys because I hear from you, and the question is, what does that really mean, and what are we going to do about our directories? I always go to that last phrase, and it says, excluding the person's name, unit designation, mailing address, and property address, and I say, well, that you have to make available. Those four are pretty clear. You have to make those available. The new legislation goes on now. It doesn't, if it's passed, it'll say, however, an owner may consent in writing to the disclosure of protected information described in this paragraph. Those of you who have been doing directories, you've probably been in the process of getting consents from your owners so you can continue to do the directory. In the condo situation, that's a little bit iffy. It's probably okay, but there's some language even in this particular statute and elsewhere in the condo statute that says a member can't waive their rights. Well, the legislature is trying to help us out. And they put that paragraph in. It says, yes, they can waive it, and you can do your directories, and you can allow additional information to be put out there. It also says in the new statute, the association is not liable for an inadvertent disclosure of this information if the information is included in an official record voluntarily provided by an owner and not requested by the association. So You've got a neighbor who's at his winter home. He's up in the mountains somewhere, and he finds out that his neighbor did something he didn't like. He sends you, the manager, an official record, a letter, and it says, so-and-so, my neighbor's doing X, Y, Z, and I'm at this address in North Carolina. Call me and we'll talk about it. That's an official record. You, the association, didn't ask for it, and he voluntarily provided it. So if you later on inadvertently let that record be given to someone else, no liability if this law goes into effect. Another big area of concern is employee payroll, employee compensation. The law's kind of been back and forth. It used to say personnel records are excluded from official records that have to be made available. We've even litigated over that subject. Did that include compensation? The judge kind of split the baby. The next year, the legislature came through with last year's law, which said personal information of employees does not include payroll. It does include payroll. So we thought that answered the question. You've got a requirement that official records, which include expenditures of the association, must be made available. You have an exemption that says payroll, personnel and payroll information cannot be. That seemed to answer the question. You can't make available your employee compensation numbers. Well, that wasn't good enough. If this new statute is approved, and it probably will be, it's now going to say payroll, for purposes of this subparagraph, personnel records does not include written employment agreements or budgeting or financial records that indicate the compensation paid to an association employee. For those of you in the condo world, take a look at the new law when it comes through, if it comes through, because the way it starts out is personnel records of association or management company employees, including disciplinary, health, insurance records, payroll, are not to be made available. Then it goes on to say the same thing I just read you, which is that they are to be made available, and it leaves open the question, I think, the way it's written, it leaves open the question of whether management company personnel records are or are not covered by the exemption. The third thing that is excluded from being required to be made available to members is the information that you get from your attorney. And that statute reads in both cases something like this: any record protected by lawyer-client privilege, including a record prepared by an association attorney which reflects mental impressions, conclusions, strategies, legal theories, and which was prepared exclusively for civil or criminal litigation or adversarial administrative proceedings, or which was prepared in anticipation, right now it says, in anticipation of imminent litigation or administrative proceedings. The new statute will change that and take out the word imminent. Well, I think that's kind of important, because I rarely write or say or send an email to a client in a case where I haven't got at least an inkling that there could be some litigation someday on the subject. So if it's not imminent, then anything I write to you is probably protected, and you don't have to turn it over if a member wants to see it. Here's real quickly on meetings of the board. Right now, as you know, in the condo association world, you have to have meetings open if a quorum is going to be present, and the only exception is if the board is meeting with its attorney to discuss litigation. The new bill, if passed, will include the board can have meetings held for the purpose of discussing personnel matters. That's in the HOA statute now. It's not in the condo statute, and so it would give you that second exception to be used in the case of discussing personnel matters. In the HOA world, the new statute, the new bill would say, unlike it presently says, it would say that Members have a right to attend all board meetings, and of course, board meetings in either case are a quorum of the board whenever they get together to discuss association business. That's a meeting. They have to be noticed. The members have a right to be there. In the HOA world, members do not have a right to speak at a board meeting. It's a board meeting. Members get to see it. They just don't get to speak. Under the new statute, if it's passed, they will have a right to speak on what's called designated items. That's what the statute says, and who knows what designated items are. We'll just have to play that one out. We wouldn't want this thing to be perfectly clear because George and Natalie and I need work to do. Talk about collections for a minute. That's probably what most of us spend most of our days worrying about. Here's a piece that's out there for both associations, condos, and HOAs. Presently, as you know, the only people who get a break whenever there's a foreclosure are the mortgagees, the banks, the lenders. They get that special break. It's either the 6 months or the 12 months or the 1%. And you can't get it all from the mortgagees, from the lenders. The new legislation has a provision that reads like this. An association that acquires title to a unit through foreclosure of its own lien for assessments is not liable for any unpaid assessments, late fees, interest, or attorney's fees costs that came due before the association's acquisition of title. In other words, the sub-association. If you represent a sub-association and this passes, you'll be able to foreclose the sub-association lien and not automatically become liable to the master association for all of those past due amounts. Good or bad, that's what's in the bill. I know it depends probably on your perspective. If you're the master association, you may not like that so well. But it's there and it could be important to us going forward. The best thing this new legislation does, in my opinion, is it cleans up a mess that was created last year when the law was written to deal with delinquencies. What it ultimately said last year in both association cases is that you couldn't enforce a fine or a suspension unless the member was also 90 days past due in payment of assessments. Now, I knew it was a mistake. I think we all did who have to deal with it, but that's what it said. And so we counseled clients, look, just do what you always do. Your governing documents probably protect you, even though it's not quite what the statute says. And the glitch bill, the one that we're now talking about, 1195, is trying to correct that, and it's done what I think is a pretty good job. It lays out, yes, you can fine for violations of the governing documents. The fining procedures are still notice and opportunity for a hearing. Same hearing process you probably remember from before. Nothing's changed there. It says, yes, you can suspend for violations of the governing documents. Same procedures. You've got to have a notice and opportunity for a hearing. It now says, and you can suspend or fine, I think, if a member is 90 days delinquent in payment of any assessments. So now they're separated. We don't have to worry about whether they got to be tied together or not. And it goes on to clear up a provision in the HOA statute which says an association may suspend the voting rights of a member who is more than 90 days delinquent. So you've got all those tools that you can use, and sometimes they're necessary, and sometimes all of those together are not enough. The changes then, we've unchained the fines and suspensions from delinquent payments if this goes through, and we allow the HOA to suspend voting rights for delinquent owners regardless of whether the governing documents provide for that. So that's a new thing for HOAs. Right now you have to have it in your documents if you want to suspend voting rights of a delinquent. If the new statute goes through, you won't need that. You could be able to do it anyway. I'm going to probably hit this really quick. Another big deal for most associations in the last year in trying to collect is whether we can go after tenants. The unit owner's very delinquent. He's got tenants, he or she's got tenants in the unit or the home, and we want to be able to get that rent money. And last year the law said that we could do it, but the law was kind of poorly written, and we weren't sure what it said. We weren't sure if you could get just the new rent or just the amounts that come due after you give notice to the tenant. Well, the new statute, if it's approved, will say you can get all of the rent going forward, and best of all, it has a notice provision. This is what you send out. It clears up some of those issues about how you notice, about whether the renter believes you. That's always been a problem for us. The renter says, "What are you talking about? I've got to deal with this guy, and I don't know who you are and why you're coming to see me trying to collect the rent, and what is he going to do? He's going to kick me out if I give you my rent." Well, the statute clears up that a little bit, and it provides that special notice. I think that's a real improvement if it goes through. I'm just going to see if there's any other thing that seems to be big enough to take up Elaine's time here. And you know, it's hard to do that when I'm not even sure this will get approved, but hopefully it will be. Here's one for HOAs that has come up on a regular basis, and that is, does a candidate have to be eligible for the board on the date that they become a candidate or on the date they get elected? And we've had that debate, we've had those problems. Well, the answer is going to be clear if this goes through, because it now says that a candidate means an eligible person who has timely submitted written notice. In other words, they got to be eligible when they become a candidate. Timely submittal follows that process where you send out the 60-day notice of the annual meeting. They're supposed to get back to you with at least 40 days before the election. That's the candidate, and that's the time when they submit their response saying, "I want to be a candidate." That's when you determine whether they're eligible. Speaking of eligibility, let me think. There's one change that seemed interesting here. HOAs do not have to allow homeowners to run if they're delinquent. That's in the new statute. HOAs cannot allow felons to run. So that's in the HOA statute now. That's in the condo statute now. The HOA statute will have a provision that says felons are not eligible to run for the board. It actually says, it goes on to say, but if they do, it doesn't invalidate anything that the board has done, which I think is telling us it's going to happen. The legislature knows it's going to happen. We can't always tell who's a felon, let me clarify something too, because I don't want to leave it without telling you the whole story. It doesn't say just a felon is ineligible. What it says is a felon who has not had his or her rights restored for at least 5 years. So when you go back, it gets a little more complicated. Be sure and call your lawyer and have them help you with the issue. Have they had their rights restored? Has it been more than 5 years at the time that they want to run?